Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Recently, charges were dropped against a homeless person who was charged with shooting a local business owner who had gone into the homeless camp in order to recover property. Now, this is a story that's got a lot of people very upset, very angry, and a lot of people have asked me, hey, Runkle, can you make this make sense? So I'm going to try. I'm going to try to explain what was going on and why the prosecution might have made the decisions that they did. That doesn't mean you have to agree with them, but let's talk through why, and then I'll give you my thoughts. So basically, the factual basis of this is that this business owner has his business broken into. Somebody breaks in and steals a bunch of stuff. And he's out trying to do his own investigation. He's looking around because police are probably not going to put this to the top of their list, and find some property that is connected to the break and enter on the road outside of this homeless encampment. And based on that figures, hey, I bet the rest of it is in that homeless camp. So he goes and gets three of his friends, and they don't have any weapons, but he's wearing a slash-proof vest, and they go in to have a look around. And they're looking around, people get upset with them, it gets physical, and somebody shoots him. At least, this is the story he initially tells the police. This is not the story that the police investigation finds, including looking at video. When the police did further investigation, what they found is that even though this guy said that he only had 4 people in his group, it actually turned out that he brought 7 or 8 people. So he was already downplaying or, misdirecting the police on that. That's a bit of a problem because once you start playing fast and loose with it, your value as a witness drops very low. So that's an issue. He also told the police that he was unarmed. But when they looked at video and when they did searches, they found that they had actually armed themselves with sticks and 2x4s, and that the guy who got shot actually had a collapsible baton. A little bit different than, hey, we're unarmed. And so what actually seems to have taken place is, upon the police investigation, is that these guys thought that there was stolen property in this camp somewhere. But keep in mind, they don't have a specific location. They're just going to go tent to tent looking. And so they got a bunch of guys and armed themselves up to do it, to invade this homeless camp. And you might not have a whole lot of regard for, the homeless and so forth, but they still do have rights not to be attacked. And so this is the concern, because later on review, they find that these people had gone in and had, for instance, thrown a homeless couple down an embankment. That's behavior that tends to create some issues. But the business owners weren't charged. Initially, the people who were charged was one homeless person who they figured had fired the shot. And that was because he was identified by one of the business owner group. And so they initially lay a charge of just pointing a firearm. Now, later, they were considering whether they could apply a bunch of other charges. And this here will answer one question that a lot of people have asked. A lot of people have said, did this homeless guy have a gun license? The answer to that is no. And we know that from the list of charges that they were planning on imposing. Those are assault with a weapon, that being a firearm, discharging a firearm with intent to wound, possession of a firearm without a license. If they ran his name and he had a license, that wouldn't have been on the list, so no license. And possession of a weapon for purposes dangerous to the public peace. But they didn't initially approve those charges because they said, hey, we need more information. We gotta know more. One of the issues was they weren't really sure about whether they could make out identity. And identity basically means, is the person that we arrested actually the person who did the things? Like, even if you know that a crime was committed, you have to make sure that you arrested the right person for the crime. Makes sense, right? But the Crown had a bit of a concern saying, hey, we don't actually understand what's going on here. This story doesn't make a whole lot of sense. can you do some more investigation? Because there might be a self-defense argument or something else here. So we need more information. And upon further investigation, they found that a lot of the stories just weren't adding up. And pretty quickly, people stopped talking to the cops. They said, hey, we're done, which is entirely within their rights, and it was probably the right call. But they'd already had information, they'd already been given testimony that the police knew to be false. That's a problem, and because if the initial story that they're getting is we were just there was just 4 of us, we're looking around, we're unarmed, but later it turns out that they're armed with sticks and a 2x4 and a collapsible baton, and they're wearing slash-proof vests and wearing motorcycle helmets. That seems a lot less like, hey, we're going to go have a look around, and more like, hey, we're going to go crack some skulls. And you can't do that. You can't, just go, especially when you don't know if the property's there. You're just having a look to to check. So at this point, you've got this group who is, and most of the people in this homeless camp are going to have nothing to do with any missing property. So some point after this group comes into the homeless camp and actually starts physically aggressing against people. There was a report that one of the sort of business owner group threatened to get a shotgun and start shooting people. So after this had already turned south, one of the police, or the Crown calls them campers, they're homeless, went and retrieved a rifle, and another one retrieved a paintball gun. And as the confrontation continued, and in fact, one of the sort of business owner group is seen striking. In fact, the guy who was shot is seen hitting somebody over the head with the baton. And at some point in there, he gets shot. Now, it's hard to tell when he gets shot. And the reason why is because he got shot with a .22, and he didn't notice that he was shot with a .22. This actually happens all the time. So if you're wondering about the great debate people have about, the stopping power of .22, this guy didn't even notice when he was shot. He found that out later. So .22, not so great on that. So the prosecution has a few problems here. The first problem is with regards to this initial charge of possession of a weapon for purposes dangerous to the public peace and possession of a firearm without a license. Because if he had the gun beforehand, they could make those charges out. Problem is, this is a homeless camp. And most of these camps aren't registered in someone's name. You don't have a lease. You don't have anything in land titles, anything like that. You're probably not getting mail with your name on it, with bills and so forth that they could use to show you live there. They're just tents. So it's going to be really hard to show that this guy went and got his rifle as opposed to getting somebody else's rifle. You don't know whose gun this is. And so you don't know if he possessed it before things went down. Because if he went and grabbed this rifle in response to an immediate sort of dangerous situation where there was a requirement for preservation of life or limb, then you're not going to be able to get that charge to stick. So at that point, the people have said, why don't they have him on the storage charges, on the possession of a firearm charges? That's why. They're not going to be able to show whose gun that was beforehand. The next issue is the whole shooting thing and whether or not they can lay charges on that. And they do a pretty detailed analysis. I'm actually going to link their explanations below, but I'm trying to provide some details here. And so the problem that they have is this self-defense or defense of others? Because if it is, and they don't have to prove self-defense. In fact, the opposite is true. Once self-defense is, once there's enough evidence that it's a possibility, that it's not sort of fanciful or far-fetched, then the Crown has the burden of proving beyond a reasonable doubt that it was not self-defense. They have to prove the absence of self-defense beyond a reasonable doubt. That's a tough thing for the Crown to do. So, if it's available, like if self-defense is there for this case, it is a complete and total defense to all of the charges here. So the question is it self-defense, or at least is the Crown going to be able to prove the absence of self-defense? Well, you got a problem, because a bunch of people armed and armored came into this encampment and then started attacking people, is the evidence the Crown has at the moment. I don't know if that's the case, but that's what they think is happening, and that's what their evidence they think is going to show. He gets shot once, and he's fine. He goes through surgery. They don't recover the bullet, but he's apparently fine. Now, he gives evidence that is contradictory and is contradicted by things that they know to be true, which means that his evidence at a trial is going to be garbage. It's just going to be useless. As a defense lawyer, I can rip that guy to bits. It's just, that's the case. That's what the Crown has to think about. And so a lot of people have said, listen, even if this guy's armed with a baton, how do you get to shooting him? Well, Canadian law doesn't require you to meet like force with like. You don't have to be exact. If somebody pulls a knife on you, you're not necessarily required to stick to a knife. Somebody's there and, they've got a knife. They're chasing you. And you're not required to only use a knife. If you have a gun, it would be reasonable to use the gun in that circumstance, because a knife could kill you. And this just makes sense, right? Because otherwise it becomes really weird. Let's say you're out hunting and all you've got is, a shotgun in your hands, and you might have a hunting knife for processing, but it's in your backpack. It's not accessible right now. And somebody comes charging out at you with a fire axe. You don't have a fire axe. Are you required to give up your shotgun so that you can go find a fire axe to defend yourself? That would make no sense. The force has to be reasonable in the circumstances, considering a whole long list of things. And when we look at it here, they're outnumbered in the sense that there's 8 guys who are armed, and you're talking about 2 people who went to get the firearms, that being the actual .22 and the paintball gun, which would be a firearm, although we're not going to get into that particular rabbit hole. And this is a physical confrontation. This is a big fight. But somebody coming at you with a baton is lethal force. That is potentially lethal. That's a problem. He's beating a guy over the head with it. That's a problem. That's something that could straight up kill somebody. It could cause them serious, brain damage or something like that. And they're wearing protective gear. So when you're thinking about what else could you do, are you going to go get your own, club or your own stick? Well, they've got motorcycle helmets and body armor and so forth. So even there, matching like force with like force isn't going to make sense. The prosecutors also noted that the campers didn't immediately arm themselves. They sort of waited to see what happened, but after the attack started, that's when they went to get their property, or get the weapons here. So they're saying, it makes sense that you would use force, and then we have a question of whether it's proportionate in the circumstances, because that's part of the reasonability aspect. But you're not required to, and this is language that shows up over and over in the case law, you're not required to weigh to a nicety the force used. And the principle there is basically, if somebody's charging you with a knife, you're allowed to defend yourself, and the law is going to recognize that this is something you have to react to in the moment. You're not going to be able to get the precise, perfect defense to that. It might be that all you can do is grab a fire axe that's right nearby and hit the guy with it. Or grab a firearm and shoot the guy. So a lot of people are not happy with this because they say, hey, listen, this business owner was just protecting his property. But it went a little bit beyond that. And I am going to note, I don't know if the person who shot the business owner or the people who were getting hit by the business owner actually had anything to do with any sort of break-in or the like. And we have to consider the possibility that they didn't. I mean, if they didn't and all they're doing is just trying to exist and they start getting beaten with sticks and batons, self-defense makes a lot of sense. Even so, even if they were going out to, arrest people because they knew that that was the stuff, you got to do it in a reasonable way, and people can be entitled to defend themselves against you. So ultimately, the prosecution determined that they had no chance. They didn't have a reasonable prospect of getting a conviction in this case. And I can tell you, they didn't. Based on what they're telling us in this media statement, and I have no reason to doubt the media statement, I think that a competent defense lawyer, or really a conscious defense lawyer, could win this case without issue. He was gonna walk at trial, straight up. So that's why they yanked it. And I know that this is something that's probably going to upset a lot of people. I know that my thoughts on this are probably not going to be universally loved, but I think this is the right call. This is accurate. This is kind of a, F around and find out situation. If you go and tool up in armor and weapons and invade where people live, then they might defend themselves. Certainly, if you got 8 guys and came into my house armed with batons and 2x4s, I would defend myself. So, yep, don't do that. Important, safety tips. I think anybody would, to be honest. And, if they've got firearms, they might defend themselves with firearms. If they don't, they might grab knives or whatever. So before you judge the prosecution too harshly, think a little bit about what you would do if there were 8 guys with batons trying to come into your house. Yeah. Anyway, thank you for watching. Please like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level: Traveling Science Man, CCFR, CAIM, Canada's National Firearms Association, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Jane Babe and Luxor. And at the $20 level, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Here's a Coin Legal Witcher, Cameron Johnson, Andrew Elsich, Vicky, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.